Good afternoon. Keep eating. Go have some more food and have some dessert. Welcome to Tucson's first jury improvement lunch. I'm Steve Sussman, the executive director of the Civil Jury Project at NYU School of Law. This is our 25th lunch like this around the country. We did one yesterday in Los Angeles, and we have pretty much covered the country, and will have by the end of the year. Typically we have jurors who have been recently discharged, but we haven't gotten any jurors to accept our invitation to come here today, and perhaps if the group decides to do it again, we will get some more jurors. We get jurors the next time, but thankfully we have judges who are familiar with the issues, and we all can get CLE credit for being here. The civil, and one of our rules is that we begin now, we stop promptly at 1:30, so the judges can get back to their courts and their trials. The Civil Jury Project was started at NYU a few years ago as the only academic center in the country that is studying the question why jury trials, indeed it turns out all trials, all public trials are disappearing and vanishing in this country, whether it's something we should be concerned about, and if so, what can be done to stop or reverse the trend. The lawyers and judges know that the right to trial by jury was so important to our founding fathers that it is mentioned 5 times in the Declaration of Independence, Article 3 of the Constitution, and 3 of the Bill of Rights. No other right gets that prominence in our founding documents. Indeed, at the time our Constitution was adopted, the constitutions of every state guaranteed the right to trial by jury in civil cases. The jury is so much part of the architecture of the justice system, the rule of law in this country, that every courthouse has, every courtroom has a jury box. This slide makes it pretty clear that those boxes are not used very much today. Over the last 55 years, and the red line is jury trials, the blue line is bench trials. The number of jury trials per federal judge in this country has dropped from 10 to almost 2. And the blue line shows, which is an incredible drop. And the blue line shows, to my great surprise, that bench trials have declined even more dramatically, which, by the way, is pretty good evidence, proof of the fact that the disappearance of jury trials is not due to some special characteristic of jury trials, either their expense or their length or the fear of a runaway verdict or the requirement of specialized advocacy experience to conduct a jury trial. The figures are pretty available in federal court, and I could get them easy. I have not been able to get the Arizona state figures. Maybe one of the state court judges can enlighten us on that. But in the federal court, the government publishes this, and we know that in this district, in last year, the average federal judge tried 2.2 jury trials, these are civil trials, and 0.8 bench trials. While that seems embarrassingly low for someone to call themselves a trial judge, nevertheless, Arizona comes in 24th in the country in terms of the most jury trials per judge and 17th for the most bench trials per judge in 2017. One might expect that the decline in jury trials or bench trials is accounted for by the fact that the filings are down. But this chart, which is the appropriate statistic, I think, to look at, shows the percentage of civil cases which are terminated by a bench or jury trial. And that shows that under 1%, about 1/2% of cases are terminated by either a bench or a jury trial. And that would have taken account variances over time of the number of cases on the docket and that are filed. Let me mention in the pattern in Arizona for the district courts in Arizona is, I don't quite totally understand that. We were able to get evidence for the last 16 years, but the trend is certainly down. And some of you who are practicing here and the judges who are judging here will have a better idea of what those statistics are. In any event, let me mention briefly what I'm doing this because some people always say, why are you doing this? I have practiced law for 50 years, more than 50 years. I've been trying cases more than 50 years, and I'm from Houston, Texas. And Texas, as all of you know, is if you ask anyone in the 60s or 70s who the best trial lawyers in the country were, half of the top 10 were always from Texas. So it's a place that should have remained heavily trial-oriented. And it was at the time I began practicing law, there were three of the largest firms in the country were in Houston. They are not among the largest firms anymore. None of them have trial departments anymore. They don't even have trial lawyers who you wouldn't recognize the names of. There's a tremendous change even in places like Texas, which I thought was the center of trial activity in this country. In any event, what we are doing, and I figured I could teach trial advocacy, but that's like teaching dinosaur hunting. I would be better spending my time going around the country saying, is there anything we can do about this? And if so, what? We have created, so some of the projects we've done, we have created several websites. The first is a website for use by judges and lawyers and academicians. And articles are there, and it's changing all the time. We list over 270 judges around the country, state and federal, as judicial advisors of the Civil Jury Project. We have 65 law professors who have written or done empirical work as academic advisors to our project. And we have 35 jury trial consultants who are jury consultant advisors because they have done a tremendous amount of work, and of course they built a multi-million-dollar industry over using mock trials and jury consultants to predict the result of jury trials and to improve the result. So that's one website. We report on this on dozens of kind of projects we're doing. One of the things we did, we did a survey of the public where we asked people who are not lawyers, do you think the number of trials is going up or down or remaining the same in the last 10 years? 80% thought the number of trials are going up. Now that was a strange statistic. And of course, if the public thinks that the trials are going up, there's little help we can get from the public or policy or legislatures or lawmakers on doing anything about the project. So when they talk about judicial emergencies, need for new courthouses, bill is introduced in Congress last week for 50 new federal judgeships around the country. I don't know who is making the case for the need, because when the judges are trying 2 cases a year, it doesn't seem to me that we need a lot of new courthouses or new judges. But in any event, that was one survey we did. We have held, as I said, a lot of these lunches. We have now brought 150 trial judges to NYU campus for a full-day workshop on how to conduct a jury trial. By the end, in 2 weeks, we'll have another 60 judges coming, so we'll have educated 150 judges. Really, we began that program because the new federal judges 3 years ago, as we were getting started, were telling us that at baby judge school, They don't even teach jury trials anymore. It's not on the curriculum. It's not mentioned. And we know, all of you know, I don't know what's happening in Arizona, it's certainly happening in Texas. The fact we have judges being put on the bench for life as trial judges who cannot spell the word trial, who have never seen one except on TV. So what kind of reception when these judges get before them a motion which either they can grant summary judgment or try a case, what do you think they're going to do? We have to educate those judges because the Federal Judicial Center is not doing it. I say we've had, this is our 25th lunch. We publish a monthly newsletter for 24 months, and you have the last 2 editions. By being here today and leaving us your email, you will get a monthly newsletter from us. Some very interesting articles, mostly written by judges about things that they are trying to do. We maintain a second website. This is only for jurors. And what we discovered when we went to Google juries and jury duties were on the social media and Twitter, and to see, we found that 90% of the people were looking for ways to get out of jury duty. That's why they were surfing the web. And so we figured, let's get them to go to a place where they will be encouraged to respond to the subpoena and go down and do jury duty. And we've done that, but we give the judges, and we will send the judges here today, because I see I must have left them in Los Angeles yesterday, these little cards that they're size of a business card that says make your voice heard, and it essentially sends them to this website, and they are asked once they get to the website to click on that icon over there, served jury duty before, and they're given a questionnaire, a feedback form. We've had hundreds of those questionnaires filled out. So there is a need for, obviously, some place for people to be heard who are jurors about their experience. They want to talk about their experience. When we have interesting people who are vocal and articulate, we go videotape them, and we have testimonials. And when you click over here, received a jury summons, you see short videotapes from people who have recently served on juries who say, don't throw away your summons, it's the best experience you can have. I'd love to do it again, and they talk a little about the experience. So hopefully, over time, this will have some effect on increasing the yield. The middle button is, and we get some people clicking there, but it says, you shouldn't be here, your judge has told you not to be here, come back when you are discharged. What we did most recently is prepare, and by the way, you may think that we don't have enough people here today, there should be a bigger audience. What are we going to do with this? What's the use of this? Every program we have done, we have videotaped. All of the 25 lunches are available on our website. You can see the jurors talk and the judges from around the country talk. We learned great things at every place. And so we tried to make a list, and we came up with 17 reasons why jury trials are declining. And we listed some that are very difficult to change. Professor Langbine of Yale says that, well, the discovery rules allow parties to know the facts of their case without having to go to trial. In the 60s and before, you had to try a case to find out what the facts were. You don't have to do that anymore. Good lawyers know the facts. And that's why mediators frequently tell us, you should be able to settle this case. You know what the facts are. You've deposed everything that moves, so you should be able to settle the case. Managerial judging, which kind of began in the federal system in '83 with Rule 16, and which essentially encourages judges to take an active control of their docket with the goal of efficiently disposing of cases, clearing their dockets, getting rid of a backlog, and not a goal of trying more cases. And that's another thing that eliminates trials. We talk about the enforceability of arbitration clauses in contracts of adhesion, elimination of cause of action. In many states, I understand you do not have tort reform in Arizona, but in most states there is tort reform. Juries are capped, punitive damages are limited, and frankly, causes of action are limited. It's very difficult. The pot of gold at the end of the rainbow, there's no longer a pot of gold at the end of the rainbow. Why? So, tort reform has taken its toll on trials, because why go to trial if you know the jury verdict that you win is going to end up before a appellate court that basically has never seen a jury verdict that they like. So why do it? Why go through it? You should settle that case, or if you go through it. In any event, so just to give you an idea of how we learn things, one of the lawyers here came up to me and said he thought that the main reason for the decline in jury trials was the lawyer advertising. I said, what? Because it ain't up here on the list. Well, it's interesting. Judge, you can talk about that a little on when we get on the panel, that the lawyer advertising concentrates personal injury cases in the hands of a small group of advertising lawyers who don't try cases but try to settle them, and takes the cases away from law firms that do go try to trial. And then on the right side, we have reasons that we can do something about, and that's kind of what I like to focus our panel discussion about today. You should have if you don't have a copy of the list on the table, I will send you all a copy of this list. Urge you to look at the reasons, tell us whether we have misclassified them or there are others that we should add. We are hearing a lot today about the importance of judicial independence and how that is assured at the federal level by life tenure. But 98% of the cases in this country are tried in state courts by judges who are either elected or subject to retention elections. Americans have always believed that juries are the best way to protect citizens from judges who may not be independent of the litigants or the chief executive. And so we can talk about whether those reasons are still valid today. So now we will begin this panel discussion with the judges, and I would like the judges who are present to come forward. From the federal court, Judge Frank Zapata, and you all should have a name tag up here, and Judge Jennifer Zips. We have two federal judges. We have from the state court, Judge Chuck Harrington, the chief presiding civil judge. Judge Kyle Bryson. Is Judge Bryson here?
I'm here.
Great.
Good afternoon.
Judge John Hinderacker. Have I got that right? Is Judge Hinderacker here? Okay. Judge Leslie Miller, I know is here. And Judge Greg Sakal. Judge Sakal. And thank you very much for being here today. So did I send you this list before you came here? You had a chance to, some of you, I did not send it to you, apparently, Judge Miller. But I think I sent it to So my question is this to you to start. What have we omitted from this list that you think is important? Or have we mischaracterized something as something we can't do anything about, something we can do something about? I mean, I know everything can be done something about with a new Supreme Court or new legislation coming out of in a state or a capital from Washington. But as you read through this, does it kind of cover it? And if anyone, so let me just ask you, Judge Harrington, what do you think is the main cause?
Well, I think there are two main causes. I think the cost of getting to trial is one main cause, and I think I think lawyers learning their craft in arbitration as opposed to in court settings is the other cause. And if I can give you an example of the first, discovery. Recently, within the last few years, one county in Texas issued an order in all civil cases that there was a very short discovery deadline, and it was a test project. Very short discovery deadlines for smaller civil cases and very limited discovery. And they didn't know what would happen to the cases, whether the filings would go down, whether they'd go up, whether the trials would go down or go up. A little bit to their surprise, the case filings went up and the trial rate went up. And when asked as to why this occurred, there were a lot of lawyers who were willing to take on cases, plaintiffs' lawyers, that previously would not, because previously, without any discovery limits, they were being run through the ringer and it would cost too much to get to take the case. But with the limited discovery, they could afford to do it. And it wasn't a killer if they lost. They also knew that it was going to happen relatively quickly. So I think that's one bit of evidence that shows that discovery costs are an issue.
Could we begin? Would you all agree that the cost of discovery in a bench trial and a jury trial are the same?
I would agree.
Anyone disagree with that? That a bench trial discovery is the same. So I have noticed in jury trials, for example, it is more expensive to go through the hoops that you have to get through. The Daubert motions, I don't know what you call the equivalent in state court, but you know, the reliability of the expert testimony. You got to survive that. And then there's motion in limine practice, which in federal court can go on forever, about what evidence the jury hears or doesn't hear. So in that respect, I guess getting through those hoops is more expensive in a jury trial. On the other hand, when you get the verdict, it's over. The fat lady sings. No one makes you get a copy of the transcript, read it all, write post-trial briefs, go in and argue 2 months later. And the trial itself tends, because of our concern for jurors, tends to be condensed. So whereas a bench trial, you might have me in for 2 hours today, 3 hours next week, 4 hours, then you're going on vacation. So, you know, and every time means I have to relearn the case, I have to set up a new trial office. So I have found that bench trials are no less expensive, maybe more expensive than jury trials. Now, does anyone quarrel with that? Yes, Judge.
I appreciate what you're saying, and you're talking about a type of case that, a large case with probably a lot of experts, and we certainly see our share of those, but they are not the predominant type of case coming through our court and most courts around the country. So in large metropolitan areas, in places with corporations, there are far more significant cases with loads of experts and those type of situations. But I think probably when you look at those numbers there, the majority of cases tried in the United States are not the cases about which you're speaking. And so I think it's really important to keep in mind that a significant number of cases, not only here but everywhere, you're talking about red car, blue car, you're talking about contract cases of small business. They just don't rise to the level of the type of case you're using as the model.
Okay. So those who, let's talk about arbitration. And we can't talk about arbitration in consumer contracts because the Supreme Court loves that. And, you know, if it has the word arbitration in it, you have to send them there. But let's talk about what we did. We did a study. We looked at every contract filed with an 8K with the SEC for 6 months of last year. And because those are the material contracts, the business to business, not the consumer contracts, but the business to business contracts. We found that only 40, to our great surprise, only 43% of them had either arbitration clauses or jury waiver clauses. Meaning, I mean, the number of contracts may not be exactly equivalent to the number of companies, but you could say that still the majority of American companies, big public companies, think that in disputes with each other, they still trust a jury more than they trust a judge or arbitrator, which to me was a ray of hope. And we went to some of these. We then called up the companies that didn't have these clauses and tried to interview their general counsel. And it was amazing how many of them said, we hate arbitration. It lasts too long. You pay 3 arbitrators $750 an hour. You can never get a dispositive motion granted because they just cut them out. They grant a summary judgment motion or motion to dismiss. They cut themselves out of work. There's no appellate relief if the judges get it wrong. And we find it just as expensive and just as time, same discovery, because after all, it's the federal and state judges that's what they do when they retire. They join jams and they become arbitrators or mediators. So, you know, they're used to the same rules of evidence apply. I'm shocked at hearing that now, a lot of that, more than ever before. I mean, I'm just talking now. I should ask you this question. So I began this project 3 years ago with the idea that I'd only be doing it for 5 years, and it would end. And unless we decided to turn it into a permanent center at NYU Law School, like the Brennan Center, which is there forever. My friends were on the bench. There were 2 attitudes. Great, we need more trial. Go to work. Glad you're doing it. The other is, Sussman, you are like Don Quixote of jury trials. The ship has already left the dock. There's nothing we can do. And so that's a pertinent question for me to ask Arizona judges, particularly state court judges. You have adopted, one of our big programs has been, and what we talked about yesterday in California, what I talk about in every other state, but here, are innovations. What can be done to improve jury trial? The state of California has the state of Arizona has, beginning in 1993 with Judge Dam, and in 1995 you have every one of the procedures in the world. Jurors can ask questions. You give them substantive instructions at the beginning. They can talk about the evidence before final deliberations. Time-limited trials, common. Everything we're preaching elsewhere. If 20 years of that have not prevented your trials from vanishing, why in the hell am I doing this? Would someone care to respond? Do we have a hope? Is there a hope here? Wow.
I don't think the rules were meant to, well, I know the rules were not meant to create or enhance jury or increase jury trials. They were meant to make it a better experience for jurors, to allow jurors to understand the process more effectively, to have them understand and engage in the case, to make it a better process for jurors to understand and deliver better verdicts. they really weren't meant to increase jury trials.
So I think there's a real great hope in Arizona. So most of the people here have heard me talk about this, but there was a civil justice reform committee in Arizona about 2 years ago, out of which came many programs, one of which I was telling you about before, Stephen, the Fast Start program. And the vast majority of that committee, which was made up of Supreme Court, appellate court, trial court judges in Arizona, business leaders, business counsel, in-house counsel, defense counsel, plaintiff's counsel, and lay people, I'll call them, were alarmed at the decrease in jury trials and believed that it's necessary to adopt programs to try to get more jury trials and to make it less expensive to get to a jury trial. So I think there is a lot of hope. I think at least at certain levels, people understand the importance of that. And I know, I can tell you, and he doesn't mind me saying it, but the man who's going to be our Chief Justice coming up soon, you'll have to cut this out of the video in case he sees it. I can't remember his name. What's his name?
Burtnell.
Yeah, Bob Burtnell, thank you.
You can keep that part in there.
He is very much against compulsory arbitration and is very, very dedicated to increasing the jury trial rate.
Let me ask a question to the federal judges. Yes, Judge.
The ones that control whether there's a trial or not are the lawyers. What do lawyers say about that? Do lawyers feel there's a need for more trials, or are the lawyers satisfied with dealing with arbitration and with
No.
alternative dispute resolution? We've gotten, you just mentioned judges that are becoming mediators, but we also have had, in the last probably 30 years, a whole cadre of people who are absolutely great at being mediators, arbitrators, settlement judges, or settlement people. So I don't, is there an outcry out there from lawyers for more trials? Is that something
Sure.
that lawyers?
The answer is, go ahead. We have in the audience.
Yeah, there is.
Of course there is. ABOTA has a Save Our Juries Committee. The American College of Trial Lawyers has been an ongoing project of it.
I think the quality of justice is better.
And the
So why
answer
don't
is,
you settle?
the
That's
answer
a-
is,
that's
I'm
a-
getting
Well,
these,
that's different. You
That's,
settle because you can assess risk.
well, that's a theoretical
Right,
point, that sure, that may be better justice, but the reality is that lawyers are settling cases at an incredible rate. About 2% of our cases go to trial. And
I would
so,
disagree slightly. I would say parties settle cases, not lawyers. I do what my client says. I advise my client, and if my client, based on my advice, says settle, it's not my role to trump it.
But I know you, and I know that you drive that machine
so let me,
as a lawyer.
let's talk about mediation.
It's true.
One of the things we are proposing, that I've been proposing, is I think it's fine to make parties mediate before they go to trial. They ought to be forced, you ought to be forced to spend a day with your client in a conference room talking about the merits of your case, which is a painful experience that we often avoid. But what I don't like and what I think is improper are for judges to order me to go and mediate before the judge rules on dispositive motion, and before the judge has given me a definite trial date in the not too distant future. Because in the absence of that, I'm settling the case at mediation for the wrong reason. I'm settling it because the judge doesn't want to do her work, or because I can't get a trial date. The system, I can look at my client and say, I don't know when this case is going to trial, maybe never. And that judge who likes you, or likes us, she probably won't be around. She'll be retired. There'll be someone else handling the case. When it goes, in other words, why would any of y'all send people to mediation before trial settings? You do.
No, I was going to tell you, I set my trials at the outset of the case with a trial setting I do it at the very beginning. I set a trial date, I set a dispositive motion deadline, I encourage people to file dispositive motions as soon as they're able, and I rule on them as soon as that occurs. I don't try any more jury trials than anyone else on the court. I do what you're actually suggesting. I'm kind of old school I've been around a long time, so I'm very old school about how I do it. And, but my system of setting a trial at the very beginning and hearing dispositive motions before anyone goes to mediation, I only require that they go to mediation 30 or 60 days before. And yet, a lot of times, lawyers ask to go to mediation earlier than I would ask them to go, and I think it's because they're interested in settling the case, if possible, before a lot of money is spent. So I don't see that as creating more jury trials or changing that in any way, because my jury stats are certainly no better than anyone else on our bench. I just think it's cost. It is so expensive. The cost of experts is so expensive. Not only deposing them, and then you've done all the depositions, but then the cost of having them appear at trial, their prep time for trial, then their appearance at trial. It's so common now that every expert will say, I want $4,500, $5,000, $7,500 given to me before the trial starts, regardless of, so many days beforehand, and that's it. And the cost is just prohibitive unless you have a truly large money verdict case.
Judge Sapp, let me ask you something as a federal judge. Why is it that the federal courts, judges who are appointed for life, who don't have to be friendly to lawyers or do what lawyers want, and who have basically unlimited power to do almost anything, why is it that they have been so slow to adopt the innovations that state courts in Arizona adopted 25 years ago? What explains that?
Did you say Judge Zips or Judge Zapata?
What?
Which, did you say Judge Zips or Judge Zapata?
No, is that, I call you.
Okay.
I meant to
I'll
talk to
answer
you, I'm
that.
sorry.
I don't know that we have been slow to adopt the modifications and innovations of the state court, and that's because many of the judges who come to federal court here in Tucson are from state court, and they're aware of those changes. I don't think everything's been adopted, but certainly I think most of the judges, if not all of them, allow, for example, jurors to ask questions during jury selection. Many judges allow the mini opening statement during jury selection. There have been modifications of jury schedules. If there are, we can have shortened days, or if there's a juror that has a particular need, we'll make those changes. So I think that we have been influenced by the state court bench, and that we have made many of those same innovations that they've made. Do you allow lawyers to do voir dire? Sometimes. I don't know that I've ever denied a request to conduct voir dire in a civil case. Although I'll give you a caveat with that, as I haven't had a lot of civil jury trials. Being a federal court along the border, we are driven by our criminal caseload. I went back and I looked at my statistics. I've been a district judge for 7 years. I've had 5 civil cases that went to trial. 4 of those were eligible for a jury trial, and of those 4, 2 elected to go forward with the jury trial, and the other 2 elected for a bench trial. So that's not a lot of experience in my own background to address that. I'm also a member of the Jury Trial Improvement Committee, which is the Ninth Circuit committee that talks about juror innovation, and talks about how to make service better for jurors, how to educate jurors on their role in our justice system and how important that is. And I think that the federal system is putting a lot of effort into addressing these concerns about the jury trial going away. I think the most important thing is, even in having this conversation here today, it's not necessarily true that other means of resolving cases aren't good means. Certainly, certain cases are best resolved by mediation or by settlement. But I think what we want to focus on is making sure that our procedures and any delay that's caused by us or expenses because of our rules isn't the main driving purpose for why somebody does or does not elect a jury trial. I think we want to make sure that that's always an option for the appropriate case.
Judge Zapata, do you allow the lawyers to go out there
I do.
and ask can the jurors ask questions in your court?
They may.
Submit written
This is,
questions.
now we're talking civil, not in
Civil.
criminal cases. Civil cases, I asked the lawyers to do a mini opening statement before to the entire panel. Mini opening statements, usually about 10 minutes, just to get the panel acquainted with what their case is about. They will then have a full opening statement to the panel that's been selected to hear their case. I do allow voir dire by the lawyers. I allow jurors to ask questions. So all of those things are in place. I think they're not codified, so we don't, people think we don't do those things, but we actually do things, and they will change from judge to judge.
Yes, and what I found is that they not only change they change from judge to judge within the same courthouse. I mean, they're judges in the same courthouse that do not know what the judge next door is doing or how they're doing. Well, let me ask you about this innovation. I was surprised to learn one of the most controversial innovations that Arizona has codified now is allowing jurors to discuss the evidence when they are together in the jury room before final deliberations. And there was 50 trials right here in Pima County were videotaped, and law professors studied them, and on the basis on that, have concluded that it's great. They listen to you have a standard instruction in state court that you give jurors on that subject about what they can talk about and what they can't do. But in federal court, I bet you don't do that, do you?
I don't do that.
Why?
Well, I haven't thought it through thoroughly enough to decide that it's a good idea, but certainly one of the concerns that I have in seeing jurors interact in criminal cases, of which I've had quite a few, is I would be concerned about them discussing evidence before it's been fully presented. And I wouldn't want the jurors having a conversation in the jury room, coming up with their own ideas about what the evidence means or doesn't mean without having heard from both parties or from having being fully instructed on particular pieces of evidence. So I have some initial reluctance. Now maybe if I looked at these studies or the 50 cases, maybe I'd change my mind. I've certainly changed my mind about whether or not there should be cameras in the courtroom and whether or not that stifles witness testimony or such. But at this point, I would have concerns because I've seen jurors who start talking about evidence, we've removed them from the jury because some of the things that they're saying are not, first they are disobeying the orders of the court, but the things that they did say gave me concern about their interpretation of the evidence and that they might get stuck on that idea early on before they had an opportunity for all of the jurors to converse.
Have the state court judges had any problem with allowing jurors to discuss the case, the evidence, without deliberating before final deliberation? Any problems?
The answer to that question is I have not. And the professor that you're referencing, Sherry Diamond, who did the experiment right here in Pima County, has written, as you know, and some of you probably know, a lot of articles. This was, as she says, it was a treasure trove of research that keeps paying her back. And she videotaped and recorded under the promise that she would never let anybody see those things. But she talks about issues coming up during trial where they were allowed to discuss and the effects of those. she talks about the issues of discussing in civil cases insurance, health insurance, liability insurance, so on and so forth. Anyway, what I'm trying to say is she has written so many articles on this, and I brought 2 of them with me today, if anybody wants to look at them. But I have not had a problem.
Judge Sakala?
I have not. I've been on the family law bench since being appointed. I had a civil practice before then, and it's a little off point, but I just want to point out, I agree that it's the expense and cost of getting to trial that's the primary issue. Because I just want to give you a for example, because statistics I saw from our court in Pima County, last year the civil trial rate was 0.67%. But in the family law cases, we had a trial rate of 8.45%. My experience on the family law, I know there's different motivating factors, but there's very few, if any, depositions. There's a few written discovery, and there's disclosure rules, and you get a fairly quick trial date.
Are there experts?
Rarely. And so a lot of the cost prohibitive factors, I mean, the trial practice that you talk about, and I hear people like Jerry Maltz and others talk about, where you figure out your facts during the trial, that's the family law bench. And even there, we're looking at a trial rate of, under 10%.
That's extremely interesting and helpful insight. And I really appreciate that, Judge, because one of the problems of being this thing is located at National Law School, and I've got good access to the federal judges, because so many people at the law school have clerked for federal judges. Everyone's clerked for federal judge. It's hard to get an introduction to the state judiciary in various states. I'm doing fine in Texas, where I'm from. But in other places, it's very difficult to meet state court judges that are trying 95% of the cases. And you are the first family judge that has been on one of these panels. So that is very interesting. I mean, we should study what those differences in family court.
And one of the issues that I see, just having a civil practice, and I think you have a question or comment in the back, the difference in family, too, is the rules of evidence are fairly relaxed. As being a plaintiff's lawyer, most of my problem was trying to get the evidence in and bringing in all the witnesses and the experts in order to present the case and the cost of that, rather than, kind of a Wild West procedure. That's allowed, for lack of a better phrase.
And these are jury trials?
No jury trials, bench trials.
All
bench trials.
Oh, okay. Yes, sir.
Judges I know have, and you presented this up here, that the cost of the case, to litigate the case, could contribute to cases not being filed and having less cases because of that fear. And every 2 weeks I'm in front of one of these judges saying you need to limit the expert cost because the plaintiff's lawyers listed this guy wants to charge me $600 an hour and we ought to cap it. I understand that. But when we look at the numbers, Judge, with regard to what's occurred in Pima County, you would think that if the high cost of bringing a lawsuit is going to discourage lawsuits occurring, we would have a drop in that. But we haven't.
But you have.
No, let me finish a second. What we know, and Judge Harrington's given me the statistics, and Jeff Bergen I've talked to a lot about this. 10 years ago, and the ones driving what we're doing primarily are tort cases and car cases and malpractice cases. In 2007, there were 1,300 cases filed that were tort and motor vehicle cases. 10 years later, in 2017, there were over 1,100 filed. Not a significant drop. 10 years ago, there were 80 malpractice, med-mal cases filed. Last year, there were 57 filed. The costs have gone up every year that I've dealt with this and hiring experts and traveling around the country, but the number of cases being filed has not significantly dropped.
Well, I'll respond. Numbers that were given to me at a bench-wide meeting last week, total number of civil cases in Pima County filed in 2007 are 11,091 cases. May I finish? The total number of cases filed last fiscal year was 6,776. So the totals across the board, there was a 39% drop in civil case filings from the high point. And you can distinguish out, huh? What cases?
Domestic cases
No, it doesn't. Those are separate family law cases that
It
are.
does include debt cases. It
So
does include
Right.
creditor, and I think those were during the recession.
Yeah.
I think a better comparison is if you look at 2004 and 2017. And if you look at 2004, there were a total of 8,800 cases filed. And in 2017, there were about 6,800 cases filed. That bunch from 2007 to 2013 had a lot to do with the Great Recession, and a lot of them were credit card foreclosures, et cetera.
But what we had with regard to that, though, is the number of jury trials. Because back in 2007, 2004, 2003, we were trying more than 100 trials, jury trials a year. Last year, we tried 27 jury trials. Now, my thesis with regard to this is, one, arbitration, mandatory arbitration has eliminated that. Well, one reason we have less jury trials is because we have less trial lawyers. We have far less trial lawyers. Everybody doing what I do for a living primarily is pretty long in the tooth. We're mostly all over 60 years old, and some of us over 70 years old. And when I came to Tucson and started trying cases in the 70s, we were trying a dozen cases a year. There were plaintiffs' law firms with stables of trial lawyers, whether they were Miller, Pitt, and Feldman, or Barber, Harrelson, and Knurk, or defense firms like Chandler, Tuller, Udall, and Red Hair that we were with that represented 50 insurance companies, and we were trying a case every 2 weeks and taking hundreds of depositions, and we learned the trade. We learned the trade. We didn't arbitrate those cases, and we could try car cases in 2 days and in 3 days and learn how to try a case and pick a jury and make no mistake. But what occurred was lawyer advertising. And I think, Professor, you need to look into that, because as soon as that occurred, within 5 years, those cases completely dried up. The plaintiff's model completely shifted. Everybody in town had had a plaintiff's case when I first got here, a slip and fall at Safeway, a rear ender, red car, blue car cases, and that all dried up. And that went to the plaintiff's law firms, the advertising firms, who never try any cases. The defense firms changed so that the defense law firm no longer has a stable of a bunch of trial lawyers, which you mentioned that in Texas. And as a result, nobody's learned how to do it.
So let me ask the panel, pick up on that training of advocates. Of course, we began hearing that as soon as I began this project. The lawyer said, lawyers don't want to try cases anymore, mainly because they don't know how to try cases anymore. Federal judges have told me, we are inviting the lawyers back in the tent to do voir dire, but when I look down the bench at the lawyers and say, now it's your turn to ask questions, they say, no, fine, Judge, you do it. You're doing a fine job, Judge. And so we have this vicious cycle or circle where lawyers, claims are made that trials are dropping because lawyers aren't prepared to try them. And lawyers are making a claim that so who's clamoring for it? The associates that come to work for my law firm. Actually, we did a satisfaction survey about 4 years ago, and one of them on an open-ended question said, when are y'all going to stop lying to us about giving us trial experience? And that hurt, because we do lie to them about the ability to get trial experience. We can't anymore. We come up with things like, well, we let them play roles in mock trial. There are some help we can get from the bench. For example, I've been preaching around the country a young lawyer's rule. I don't know whether y'all have it here, but the rule that says it's done by individual court order. If you have a case, an argument on a motion that is going to be done by a young lawyer or an experienced lawyer, and you define it, age, experience, whatever, you notify me, and I will assure that you get an oral argument. If it's going to be someone who's experienced, forget it. And that apparently has been very effective in courts that adopt it, in getting not only young lawyers, but female lawyers on their feet arguing motions, because it turns out that just statistically in law firms, they do more of the brief writing than men do as young associates. And if you have a rule in the firm, encouraged by court rule, that if you write it, you get to speak it, we would get more lawyers on their feet. So would you all be willing to consider something like that? I mean, you could even do it with trial. If you tell me a young lawyer is going to be the lead trial counsel, meaning making the opening statement, part of the closing argument, and a few key witnesses, I will give you a preferential setting of a civil case. You could do that. What's wrong with that?
I do think you should know that I don't think that we are not a backlog system like others. So when you talk about the delay of trial, if someone is ready to go to a jury trial within 6 months, I'll set them within 6 months. I don't think I'm usually telling people who give me a suggested trial date that what they're suggesting is too far away and they need to move it up. Than the other. I mean, I've never told anyone they can't go to trial when they're ready to go to trial. And I don't think that Pima County is one of those places where we've got the kind of backlog that interferes with anybody who's ready to go to trial. So that's just one thing for us that I don't think is part of the issue.
Can I comment?
Sure.
We have a whole bunch of stories from the old guys, which now we're the old guys. And I had an experience this week that kind of was like the old days, and I loved it. I told you about this Fast Start program. The two lawyers called me, the plaintiff's lawyer and the defense lawyer, and they said, we've never tried a Fast Start case. Would you mind if we came over and chatted with you? No, come on over. So we sat for 2 hours. We went through all the rules. We talked about what's going on in the courtroom. They're going, we're a little nervous about this. I said, okay, and it helped me understand the position they were in. I had never done that with lawyers since I went on the bench in '99 till this week. And I thought it was absolutely wonderful, and I'm going to try to encourage more of that. That's kind of along the lines of what you're talking about.
What is that program, Judge?
So it's called FastStar, and it's a program for cases of $50,000 and under that have to be tried within 9 months, very limited discovery, to make very strict time deadlines.
Let me ask, on that subject for all of you, do you all believe in setting time deadlines on trials? Your Rule 16 allows it in state court, right? So how about the federal judges? Y'all set time limits?
For completing discovery and filing a
No,
motion.
for the length of the trial. This trial will last for 10 days. This trial will last a week. Each of you get 10 hours on a clock trial.
I haven't set one.
I don't set limits. I ask the lawyers how much time they're going to need, and once they tell me that, that's what they're going to get. They're hard pressed to go beyond that, but generally they tell me what they're going to need, and it comes up far short of that in the actual trial.
Can we go back a minute to the issue of training lawyers and having a rule that would permit young lawyers to get into court and make those arguments? In federal court, we're working on formalizing a pro bono panel where part of the goal of this is that young lawyers would get an opportunity to get into court and to represent somebody during a trial. And they're coming up in our 1983 prisoner cases where it would be a benefit to everyone if there was representation. Once a case gets near or survives summary judgment, then our goal would be to appoint counsel for the prisoner, and that's one of the ways that we're hoping to help people develop skills and get into federal court and to have that experience.
Some federal courts, not all, unfortunately, are posting on the internet, making available to law firms the ability to volunteer for trial-ready pro se cases. Not,
That's essentially what I'm saying.
for trial-ready cases, so we know, and because all the law firms would agree to do it. I mean, there's some law firms now that are taking on entire dockets of cases employment cases for basically nothing, just to get their young lawyers to have trial experience. Because the thought is, if you want trial, if you're in a law firm and you want trial experience, you better go to the DA's office, or the U.S. Attorney's office. So it's really hard to figure out how you're going to provide opportunities to young lawyers to learn how to do these things. How about, let's talk about jury selection a little. Do the judges here, do they allow lawyers to submit substantive questionnaires, if they agree on a questionnaire, to the venere before they come to the courthouse? Is that allowed?
We do not accept in extraordinary cases, and the reason being the cost.
The expense. And I assume it's the same in federal court, pretty.
I mean, I've always allowed it when it's been requested, and I don't know that I've had a civil case where it was requested. Maybe there was one, but in criminal cases, certainly it's been done. The difficulty is if you're talking about expense and delay, that's an additional expense and delay is preparing a questionnaire, but we have submitted them to potential jurors.
Many years ago, that was done in criminal cases. I'm not sure because I was a federal public defender. During that time, for a number of years, every case had a jury questionnaire that went out to the venire. And we would sit there and go through them, through each one, and then remove people and so forth. Eventually, the judges just gave up on it. I don't know if it was too cumbersome for them, because they would basically have to sit with the lawyers as we went and said, okay, I want this person off, I want that person off. And so that, I think eventually it just wore them down, and it just disappeared. But we did have that at one time. We don't have that.
Interesting.
We don't have that.
So I try to get lawyers to agree to things in trials, and I've been very successful. I can almost always get them to agree to it. Both sides want to know more about the jury venire. So both of us can agree easily on a questionnaire. We can even agree on what goes on the questionnaire usually. The one side will get one question, the other side will get another question. But I've found some judges are very reluctant to send out the questionnaire. One time we both agreed that the question that would tell us most about who we want on the jury is what person, living or dead, would you most like to have dinner with? True, that's a kind of, why is that relevant? You bet you it's relevant. And it was relevant in selection of the jury and relevant in what the jury did. So, but the judge in other cases seeing that question said, you're not going to ask that question. It's not, but I don't know why not. Would you allow that to be asked, Judge Zips?
If you told me that both the parties agreed that that was a question that they wanted to be asked and it was a civil case, then I'd probably allow it. I probably wouldn't allow it in a criminal case. Just because we don't want to open a can of worms as to all kinds of different areas. But in a civil case, if the party said that's what they want to do, I'd probably, and it's stipulated, I'd probably allow it.
In a criminal case, you'd worry they might say Jeffrey Dahmer.
The thing that we hear most complaints about when we have jurors on the panel is repetition. The lawyer, we could have gotten it the second time. We didn't need to hear it the third, fourth, or fifth time. That the trial lasted too long. That they could have, regardless, 3-day, 5-day trial, they could have almost all decided it earlier. And the other thing is they don't like the process of showing up at the courthouse, going to the assembly room, having to sit around for a long amount of time. And then they don't really like the voir dire process. I mean, they think the questions, they don't quite understand it, and they think it's a waste of time. So what can we do to, why can't we, for example, since you can do everything online today, I mean, you can buy a home, you can buy cars, you can have a vacation, you can transfer. You can do anything online, boat. Why can't we make it easier electronically for jurors when they receive a summons to go online, to watch a video about what this is about, to answer a questionnaire, to be told what the dates of the trial are going to be and how long it's going to last. So, and if they have any hardships, put it down, and to do all this in advance of them coming to the courthouse. So once they come to the courthouse, they're on the jury. They just report. Judge that.
I think we could do that. I think there's recommended best practices, and many of the things that you mentioned are part of those recommended best practices.
Does anyone? Yes.
As a staff member in a very large county, in Maricopa County, moving through the jurors like that, that's a staff training issue, that's a people training issue, that's a design of our courthouse issue for bringing people in and out. To have all of those jurors have a questionnaire ahead of time and be guaranteed on a panel, when I can't guarantee that I'm going to run 7 panels that day, I want to make sure I use those jurors that are getting called in effectively. I want to make sure that they make it to the next place. If I have that questionnaire ahead of time that's limited to that particular case, then I'm calling in way too many jurors. So Maricopa County on a good day is bringing in 11 or 1,200 jurors between the morning and the afternoon. I can't guarantee that was a civil case, a civil short trial, a criminal trial. Those people are getting moved through and recycled. And even if they didn't pass the panel for cause on their criminal case, it doesn't mean that they wouldn't make an afternoon civil panel and go back and do that entire process over again. So to be able to use those people very efficiently, that ahead of time questionnaire, makes it very limited to that individual case, which I just couldn't guarantee would make it to that day. Settle on the courthouse steps. But it doesn't mean that I don't have another case that they would be eligible for. And especially with the randomization of jurors, where we're calling them, how the computer systems work, the things that we set up, that's a really difficult, on a larger administration.
Got it. So that would be an argument in favor of differentiating maybe between small cases, run-of-the-mill cases, and anticipated protracted cases.
Maybe, but even if I had an anticipated protracted case, what's the harm in me bringing in those 200 jurors and doing the questionnaire in the courthouse where I have those people live? You can get those questions filled out, given to the judge and the jury, and the judge and the counsel can look at those things quickly, efficiently, and I can tell jurors right away, you can go home. They don't, your service is done for the day. I can do that much quicker with them live and in-house than I can through the mail. And Maricopa County does make you go online, register, and watch a video. It preps you for that. I mean, that's part of the deal.
One final question. We're out of time. I think it's been great. One final question for you. What some judges are experimenting now with, the one innovation that was suggested by a former judge, Yarman or something, who's written on your innovations here, state court judge. I was just reading it, that have not been adopted here. Judge Yarnell was a judge, wrote this on Arizona. He said we should give the juries, one thing we should consider is giving juries more instruction on how to deliberate, how to select a foreman, how to conduct their deliberations. And what would you think about that as an idea? Do you think it's not necessary?
What would the instruction look like?
I don't know. And the final thing is some judges are requiring the lawyers to make a complete opening statement before voir dire, before jury selection begins. In other words, the lawyer it's not a mini opening. It's not a brief opening. It's your only opening. You make it, each side gets 30 minutes or whatever time you're given specify the time for the opening. And that's your complete opening. And the judges it's been done in federal court in Kansas. Judge Martin has done it. We have sent researchers to his courtroom to talk to the jurors who were not selected. They loved it because even though they weren't selected, they thought their time was well used. The lawyers loved it because they thought they got a better quality of voir dire, more fulsome answers. and were able to exercise their strikes more intelligently. So there's an idea that you might all consider. I don't think there's anything that would prevent you from doing it. But, well, thank you very much for coming, and thank the judges for being here and sharing this with us. Great ideas. We're going to study them, watch the video, and go from here. And for all the judges that are here, I invite you to become judicial advisors of the Civil Jury Project. It just means that you're going to be on our mailing list. And we would like, well, there is another benefit, and that is you will all be invited to New York City at our expense to do one of these day-long workshops. And we should be well represented by Arizona at that workshop because, after all, this is where it all began. I mean, y'all are doing all the innovative things that are not being done elsewhere. So thank you very much for coming. Appreciate it.